falsehoods of the same evidence that is contained in Wameli. And my point is, those same averments which are repeated in the affidavit of the applicant are equally falsehoods. My lords, the effect of that would be to leave this application with no supporting evidence at all. My lords, I submit that even if the doctrine of severance were to apply, and these particular paragraphs are removed from the affidavits, it would leave the application without any sufficient evidence to prove special circumstances. So, my lords, it ought to be dismissed. My lords, the case of Bitaitana was referred to this court, authority number, I think it's 7, number 3. That authority, my lord, on the point of falsehoods in an affidavit is very instructive, because affidavits are documents that are taken, or statements taken on oath. My lord, the petitioner, the applicant, seeks to file 200 affidavits. My lords, my count tells me that we are on day 18 from the filing of the petition. My lords, those affidavits would require sufficient time for the respondents, particularly the second respondent, to reply, and that would make it difficult for the court to make its decision within the time. My lord, the affidavit of Mr. Stephen Tashobya, commissioner with the second respondent, brings out very clearly the matter of the great prejudice the second respondent would suffer if this application was allowed and 200 affidavits are served, which would require consultations on the affidavits, looking for witnesses, interviewing them, recording the affidavits, and filing. So, my lord, even if that would take just 6 or 7 days, as Counsel Segona indicated to this court, that would in effect mean that the time this court has to make its decision is reduced by that same number of days. My lords, this is a presidential election petition, and the Constitution and the Presidential Elections Act require that this court, within the 45 days, comes up with a decision, but also with the reasons for the decision. My lords, how can that possibly be done in a space of just 3 days? This is where the application is taking us to. My lords, the grave injustice and prejudice that will be suffered by the second respondent is indeed highlighted, as I said, but also the grave danger of a crisis that this court warned us about on the 11th of February is becoming real. And all this within the context of an application that is based on falsehoods, dilatory conduct, and inconsistencies. My lords, I would like to refer to the earlier authority of Raila Odinga. At the same page, about the 10th paragraph, and because it's quite instructive, I request my lord to read it somewhat in extenso. The Supreme Court of Kenya said the other issue the court must consider when exercising its discretion to allow a further affidavit is the nature, context, and extent of the new material intended to be produced and relied upon. If it is small or limited so that the other party is able to respond to it, then the court ought to be considerate, taking into account all the aspects of the matter. However, if the new material is so substantial, involving not only a further affidavit, but massive additional evidence, so as to make it difficult or impossible for the other party to respond effectively, the court must act with abundant caution and care in the exercise of its discretion to grant leave for filing of further affidavits. And at the bottom, my Lord, the Supreme Court of Kenya held that we hold that if we allow the 7 affidavits to remain on record, the same will be prejudicial to the respondents. And this will amount to a miscarriage of justice, and we cannot allow it in the circumstances. My Lord, those were just 7 affidavits. Here we are being told of 200 affidavits that are going to be served on us if this application is allowed. That would result in great prejudice to the second respondent, I believe to the other respondents as well. My Lords, I would like to submit that this application is as well an abuse of the process of this court. My Lord, when this court is exercising its discretion, it must prevent abuse of the process of the court. And abuse, my Lords, is where a party uses litigation for improper purposes. We have the evidence on record of Mr. Tashobya, paragraph 17 to 21. My Lords, I'll not dwell so much on this material because it was covered. My Lords, I was making the point that it would be an abuse of the process of court if a party comes to the court in bad faith, and I was trying to demonstrate that bad faith by referring to the affidavit of Mr. Stephen Tashobya. So the contents of paragraph 17 to 21 have been somewhat covered by the learned Attorney General in his address. I just want to say that they're also on record as evidence. Mr. Tashobya says that shortly after the applicant instructed his lawyers to file the application, the applicant called a press conference, which Mr. Tashobya watched on television. In the said press conference, the applicant launched a scathing attack on this court in general, and he mentions the particular justices which the applicant mentioned by name. Then in 19, the applicant petitioner states that he filed a petition to expose this honorable court, and that this court has not waited to be exposed, but that the court has instead exposed itself ab initio. My Lord, that is the applicant before you who seeks your discretion to extend time. But this, my Lord, demonstrates that he's coming to you in bad faith. This is evidence of utter bad faith. So, my Lords, Article 128, Clause 2 of the Constitution provides that no person or authority shall interfere with the courts or judicial officers in the exercise of their judicial functions. The petitioner cannot, on the one hand, instruct lawyers to file an application, and on the other, publicly attempt to blackmail this court to grant this application. My Lords, in my submission, this is a classic case of abuse of court process. My Lords, I'd like to rely on the case of...
Counsel, you have 5 minutes.
Much obliged.
Concluding.
I'd like to rely on the case of Venkata Reddy, it was cited earlier. The point in that case is that it is not permissible for a party to file pleadings and go out on a fishing expedition to look for evidence. I think it should be the other way around. A party should get the evidence and be convinced that the evidence creates sufficient grounds to move the court for the reliefs he needs. So, my Lords, I pray you find this to be a fishing expedition, which you should disallow. My Lords, as I conclude, my learned friend, counsel for the applicant, did mention witnesses, and he says some of them are missing and so on. But my Lords, he did not supply any list of witnesses with his pleadings. And he cannot come to court and say that these unknown witnesses are missing. My Lord, that is evidence of another fishing expedition. My Lords, as I conclude, The authorities that were cited to you by counsel for the applicant make one clear point, that there must be sufficient cause before extension of time is granted. They also make the point that there should not be dilatory conduct. My lords, the evidence before you, the submissions, prove the fact that there is a lot of dilatory conduct. There is a lot of falsehoods that were filed to support this application. And my lords, there is no sufficient cause or at all for this application to be granted. I invite your lordships to dismiss this application and make an appropriate order for costs. I so pray, my lords.
Thank you. Yes, Attorney General.
Thank you, my Lord, the Chief Justice, together with the justices of the Supreme Court. First of all, my lords, I'd like to associate myself with all the submissions that have just been presented by the first and second respondents. But I'll proceed to submit my submissions on behalf of the third respondent. I would therefore request that you kindly bear with me as I occasionally try to veer away from what they have already very successfully, in my opinion, addressed. My Lord, of course, it reminds me of your earlier remarks to me about ceding my birthrights. I have now found that most of the items that I was going to present have been very capably traversed by my colleagues. Nonetheless, my intentions, my Lord, is to contend that the applicant has a very high burden to illustrate to this honorable court that sufficient cause exists to grant the prayer. Insurmountable, in my view, an insurmountably high burden, in my view, to illustrate to this court that he has shown sufficient cause to exist. He's praying for an extension of time that was earlier granted to them by this court for him to file additional affidavits. Now, my lords, his ground 2 filing of pleadings in this petition is still ongoing, as he says. I contend that the filing of pleadings ended on the 4th day of February 2021 for the third respondent. As soon as we filed our answer to the petition, the time ended. The time for filing pleadings ended. That action in itself closed the filing of the pleadings in this petition in accordance with Rule 8, Sub-Rule 1 of the Presidential Election Petition. That rule is clear. If the respondent wishes to oppose the petition, the respondent shall, within 3 days after the petition, file an answer. We did that. Pleadings were closed. We submit it is therefore factually incorrect that filing of pleadings is still ongoing. As a matter of law, pleadings were closed on the 5th of February 2021 for all the respondents when all the answers to the petition were filed and served on the applicant. And the court proceeded after that to set dates for trial of this petition. My lords, you will find that in Rule 10, Sub-Rule 2 of the Presidential Election Petitions Rules, which of 2001, which provide that when the petition and answer have been duly served and any application for further and better particulars has been determined, which wasn't the case here, or as the case may be, where a notice of intention not to oppose has been served, which is not the case here, then the court shall set a date for trial of the petition, which shall be within 5 days after the date in which further and better particulars were ordered or agreed to be given. So all this was done, my lords, and the pleadings were closed. My lords, on the 9th of February, we appeared before you when the applicant moved this honorable court seeking to amend his petition at that time. We duly filed our pleadings. This court considered the matter, and a decision was made later that day, disallowing the application. Following that ruling, my lords, timelines were given to the applicant to file additional affidavits. The applicant, as is illustrated in paragraphs 13 and 14 of his affidavit, is now asking court to reconsider those same issues that we think were already adjudicated upon and the finding already given. Now, in any case, my lords, the matter was traversed in that application, and the position has already been confirmed by Article 1042 of the Constitution and Section 59(2) and 3 of the Presidential Elections Act as amended. My lords, ground 3 is that filing of the additional affidavits is necessary to enable this court, this honorable court, to effectively inquire and determine all the questions involved in the petition. And his ground 4 is prevailing special circumstances warrant the grant of this application. Regarding both these grounds, my lords, the applicant contends that the filing of the additional affidavits is necessary to enable this court effectively inquire into and determine all questions involved in this petition. It appears to me that the applicant has a misconceived notion that this petition is an inquiry into the electoral process. This is not the case. This matter is in fact an inquiry into the petition itself. And as we all know, with strict constitutional timelines for this honorable court to conclude as we have already earlier submitted. It is our view, and we argued this before, that if the applicant is allowed to continuously file affidavits, it's extremely likely that we shall end up not meeting the constitutional set timelines to pass judgment. As I've already noted, Article 1043 of the Constitution directs the court to inquire into and determine the petition. I just would like to repeat that, to inquire into and determine the petition. Two things are envisaged by the provision. First is for the court to make an inquiry, and this of course involves taking evidence from the parties and the witnesses. Secondly, on this point, when the applicant's counsel appeared here, remember I requested that I might find myself veering into what my colleagues have already addressed, but I have no option on behalf of the third respondent. When the applicant's counsel appeared before you on the 11th of February 2021, he informed this honorable court that he had 50 affidavits and that they were ready for filing, and on that day, and that he was seeking leave of this honorable court to file another 50 affidavits by the following Monday, which would have been the 15th of February 2021. This court, however, exercised its discretion and gave orders on the mode of the proceedings, and even gave him more time now to file all his additional evidence by the 14th of February at 5 p.m. And the court went ahead to give and emphasize the timelines. Of course, my lord, I think this has already been traversed already by the court. It was in fact found that he had affidavits that had been sworn on the 9th and some on the 11th day of February. I think the court interrogated this together with the counsel for the applicant, whereupon court was wondering why counsel was to bring this application after all the facts that preceded the 17th day at 5 p.m. Court was wondering why this applicant had to wait this long. It is also important to note, my lords, that in paragraph 14 of this applicant's affidavit supporting this application, he deposed that on Thursday, the 4th of February 2021, he had paid the prescribed fees for his application to seek leave to amend his petition and adduce additional evidence. Clearly, at this point, he already had all the additional evidence that he was intending to rely upon in his petition. My lords, I'm talking about the 4th of February he himself has said that he had paid the fees. However, we were only to receive 50 affidavits in support of this matter later, and 3 supplementary affidavits on the 14th of February 2021. 14th February is another 10 days after the 4th. Clearly, by his own submission, these affidavits were ready by the 4th. They elected to wait until the 14th to serve them on us. As I was listening this morning, my lords, the court interrogated the question why, if and what the motive was for the applicant, for the counsel for the applicant, to delay and file things at the very 11th hour if they had them way in advance, seeing that the court had instructed us on both our obligations to this court and to our country, for that matter. I failed to find the answer to that. In paragraph 17 of the affidavit in support of his application, the applicant boldly avers that given the previous procedure in 2001, 2006, and 2016 petitions, he claims with a more limited time frame, he should now be permitted to produce evidence for a substantial duration of the trial. He seems to indicate that the previous procedures in 2001, 2006, and 2016 now give him the leeway to produce evidence throughout the trial. Actually, I'll remind counsel for the applicant that it was on the basis of 2001, 2006, and 2016 itself that this court found certain loopholes, a result of which they gave the Attorney General directives to extend the time to file petitions because of the importance of presidential election petitions. So the law is now. The law is not as it was in 2001 and 2006. There were specific changes that were, as I said, the instruction of this court in 2016. This court made those recommendations, and the Constitution and the Presidential Election Petition Act were both amended to give the applicant more time. It was formerly 10 days and is now 15 days in which to file their petition, in order that they could collect the evidence and file the petition. It is inconceivable that at this point now, the applicant is trying to seek further extension of time to file even more evidence, having already been granted more time by the court. We think if the court does this, it shall be rewarding him for dilatory conduct in these proceedings. My lords, the last time we appeared before you, on the 11th of February, 2021, counsel for the petitioner categorically informed, and the counsel for second respondent, Mr. Masiko, has just said so, categorically informed this honorable court that he would abide by the directions of the court, which were that they would file all the affidavit evidence by the 14th February, 2021. The court did emphasize that there will be no exceptions for parties that fail to meet the set timelines of court. The court said there will be no exceptions. But even if we leave what the court said aside, counsel, he himself said that now going forward, I'm going to abide with everything that you are going to say. He leaves me perplexed. In the Court of Appeal case, by way of some authority, Amrit Goyal versus Hachiband, it's in our bundle of authorities. At page 4, paragraph 6, it was stated that a court order is a court order. It must be obeyed as ordered, unless it is set aside or varied. It is not a mere technicality that can be ignored. It's the first case in our list of authorities, in the respondent's list of authorities, my lords. It is therefore our submission that the circumstances are such that this application is brought in bad faith. As I've already said, since firstly, counsel for the petitioner is on record promising to abide by the court's orders to file on time, and secondly, we are saying on the basis of all the activities that we have spoken about earlier, starting from the 4th, there are no special circumstances that have arisen, certainly none that have been demonstrated after the set time frames of the court, after we have due considerations for all the parties' interests. In this case, I mean both the petitioner and the respondents. Now, we wish to illustrate to the court that contrary to the orders of this court, the applicant and his counsel have elected to adduce falsehood in evidence. My lords, I will omit that because I think it was quite well traversed by counsel for the first respondent. And I associate myself with both his submissions and his requests vis-a-vis that particular aspect about falsehoods. The only thing one might add, my lords, is that extension of time is not a right of a party, ipso facto. It's not a right. It's a remedy that is only available to a deserving party at the discretion of the court. It is our submission, therefore, that equity demands that for the applicant to seek extension of time, he cannot be allowed to use falsehoods. That's the only thing I wanted to add on my counsel for the first respondents' quite adequate submission on falsehoods. You cannot be allowed to seek extension of time after you are using falsehoods. That alone should get your application dismissed. This submission is buttressed in the case of Anthony Okello versus Ojok, Bileo, and 2 others. This, my lords, has a persuasive value for you. It's miscellaneous application number 26 of 2006, arising from an election petition of number 003 of 2006. His Lordship, Justice Musota, cited with approval the case of Bitataine versus Kananura, a 1972 High Court bulletin, wherein it was held, and I quote, that where there are falsehood in affidavits, the entire affidavit has to be disregarded and the application rejected. Where an affidavit in support of an application contained obvious falsehood, such falsehood rendered the entire affidavit suspect, and an application based on such affidavit must fail. My lords, this is case number 4 in our list of authorities.
Learned Attorney General, and there are some authorities which say you can sever, providing for severance, that a witness might have told lies in part of the evidence, but may be found to be truthful in the other parts of...
yes, my lords, and that's the trouble.
Are you saying affidavit evidence, that rule does not apply to affidavit evidence, where out of 10 paragraphs, 3 might have been lies, and 7 are permissible?
Most obliged, my lord. That is the trouble with falsehoods, my lords. You never know where they start, nor where they end. Because once you have 8 paragraphs and 5 are falsehoods, you will never know.
No, if the person is saying, I am the applicant in this matter, that's the truth.
That,
I mean, as an example, assuming the deponent is the applicant, and say, look, I am the applicant in this matter, that is a statement of fact. It is truthful. And then the second paragraph is an outright lie. It is proved to be a lie. The third, the fourth, and then the others are clear, truthful statements. What do? Do you even throw up the part where he says, I am the applicant, which is not in doubt? Or do we apply the other principle? I cannot cite an authority now, which provide for severance.
Neither can I, except
Yes,
that
yes.
if I were to accept any averment of that, it is that the applicant states who he is. After that, how can I know about where the lie ends and the truth starts, my lord? Apart from the fact that he says who he is, because I know Honorable Segona, and if he swears that I am Honorable Segona, I would also agree that that's a fact. After that, if he confesses to several falsehoods, I find, and this court seems to support this case seems to support me, that I cannot stop. These falsehoods would make him disbelievable, basically, to just make him disbelievable. Because in any case,
that's what the authority says. But there are other authorities which say a witness might have indulged in deliberate falsehood, actually outright lies. But yet you might find that the same witness is very truthful in other aspects of the same testimony. So the authorities say you sever. Say, look, this is proven to be falsehood. We don't accept it. But these are truthful.
I would be happy, my lord.
As for the procedure of you need some of those authorities?
Yes.
Court will supply you.
Yes, my lord.
For your record.
But my point being that even if the authorities were to find that you can sever, the weight that you would give to the evidence of that deponent must, in and of itself, my lord, be of suspect value. My lords, ground 5 of the applicant, he says he has brought the application without any delay. Regarding this ground, the applicant avers that he has brought it without any delay. Now, this was, of course, interrogated in some detail. The time frame set for them to file their pleadings was 14th. This application was only filed on the 17th February 2021. My lord, you interrogated the time, which was 5. It is our view that this applicant only filed this application as an afterthought in a misguided attempt to try and extend the time to file additional evidence. We think that this court should not accept such professionally bad practice in the Supreme Court, and even worse in a presidential election petition.
And since you're here, you're head of the legal bar.
Yes, my lord.
What do you say about counsel who makes an outright falsehood, deliberate falsehood?
Yeah, my lord, of course, as the head of the bar, our disciplinary organ is the law council. And first of all, it would be straight away to refer.
Is there something like a peer body, you know, where before you go to law council? Because it seems to me there's a problem of how lawyers as professionals are being brought up these days. Do you have an arrangement where senior members of the bar sit down with the young ones?
I think it's a good idea, seeing that it is becoming common practice.
Yes.
That we find some mechanism to really, especially the younger members of the bar.
Yeah.
It's a little bit more embarrassing when it is from very, very senior members of the bar. But I agree that we shall be looking into the rules to see how we can create some other mechanism prior to going, or some peer interactions with counsel.
Why I'm saying this,
yes, my lord.
It was in contention, we took some time. But Councillor Bega said, no, the truth of the matter is that it is what the registrar said, not what appears in the other affidavit. That's what I call professional responsibility. Find yourself in the wrong, you concede. It makes you greater than somebody who insists on. So do you have a mechanism? Or if you don't, as you've said, you know, I'm not saying the law council should not come in, but you don't help. You just punish and somebody goes. I think if you can establish a system where your periodic meetings, when you find things are going wrong. You have periodic meetings. You have peer groupings. Will you or if one of you has erred, some people sit down with him or her and say, we don't do this in the legal profession.
Yes. Yep, much obliged, my lord. I agree. We shall look into creating such mechanism. I will even invite Honorable Segona to be one of the first members on that panel so that he can tell them that when I was confronted
I'm
with
sure
this,
Council is honored
yes,
to be nominated in such a peer grouping.
that when I was faced with this, I spoke the truth.
At a different forum, my lord, I would take the honor.
Okay, thank you.
Yeah, where you can say when I was faced with this, I did the right thing. So as I was saying, my lord, in our view, then I will go, to ground 6 and 7, which says that the respondent shall not be prejudiced by the extra time being granted to the petitioner to file and serve the additional evidence in the petition. And that in the interest of justice, equity, and fairness, that the applicant be granted extra time to file and serve the additional evidence in the petition. My lords, that the respondent shall not be prejudiced by the extra time being granted to the petitioner to file and serve. In regard to these grounds, it is the submission of the third respondent that of course we shall be seriously prejudiced, my lord, in the event that the orders being sought are granted. As far as the third respondent is concerned, we have concluded the preparation of all our affidavits. And in fact, we are due to file them in this honorable court tomorrow, the 20th of February. My lords, today was our day for going through them, proofreading them, and doing all the rest of the business pre-filing. But we are here. So we'll be seriously prejudiced, my lord. You see, my lord, and I think you kind of interrogated this in the beginning, together with the counsel for the applicant, where the matter was discussed, and my lord, the court ended up doing some arithmetic and saying that the court would have only 5 days to present your judgment, where this to be granted. The Honorable Segona, graciously, I think, or so he felt, offered to give us some of his days. He said, I can give them 1.5 days. But my lord, I thought that was really a mockery, because you are proposing to give 200 affidavits, and then you are offering, I think graciously in your opinion, to give me 1.5 days, and hoping that I will do justice to the respondent. My lord, with due respect, this is not possible. Because when you talk about 200 affidavits, you are not talking about 200 affidavits in and of themselves. It entails us reorganizing all our witnesses from all the parts of the country in order for them to respond to these, as I understand, would be fresh items raised by the applicant. In any case, one affidavit could quite easily elicit the necessity of 6 other affidavits in response of the same. My arithmetic shows that then we would need about 1,200 affidavits in response, if I'm to take 6. It might be a big number, or 4 per affidavit. So it is not enough to say that don't worry, you shall not be prejudiced because I will give you 1.5 days. With due respect, my lord, we think it would prejudice us. And again, I will refer, my colleagues, my counsel for the second respondent has already referred to this case, but there is a specific paragraph in this Raila Odinga case specifically talking about the prejudice. Why I'm bringing this up, my lord, was that counsel for the applicant, in my view, addressed our potential lack of prejudice rather flippantly. And in this case, the Raila Odinga case, the specific paragraph is, and I think it has already been read, but I must read it, is that the other issue the court must consider when exercising its discretion to allow a further affidavit, in this case 200, is the nature, context, and extent of the new material intended to be produced and relied upon. If it is small or limited so that the other party is able to respond to it, then the court ought to be considerate, taking into account all aspects of the matter. However, if the new material is so substantial, I'm not sure that I would be wrong in asserting that 200 affidavits is substantial. So it says, if the new material is so substantial, involving not only a further affidavit, but massive additional evidence, so as to make it difficult or even impossible for the other party to respond effectively, then the court must act with abundant caution in the exercise of its discretion to grant leave for the filing of these further affidavits and or admission of additional evidence. As counsel for the second respondent already said, in that case, the court said no. The number of affidavits were only 7. I don't even know the math of division between 7 and 200, but it is our opinion that the same will be hugely prejudicial to the respondents. So prejudicial as to amount to a miscarriage of justice.
Learned Attorney General, I think
yes, my lord.
The case for the petitioner applicant is that, yes, these affidavits are 200, but this is in the special circumstance where he accuses officials under you of abducting, detaining, making it impossible for the petitioner to pursue his petition, which was not in the Kenyan case. What do you say?
And that presumably, my lords, was his paragraphs 18 to 23. That is where those allegations were made. That he was constrained to file his additional affidavits because his witnesses were all over the country. But my lord, when you come to the court, everything becomes a matter of evidence. There is no evidence of who these witnesses are, where they were incarcerated, since he claims now to have them, or to have their affidavits, in order for the court and or the respondents to make a response to these allegations. It only leaves us with the conclusion that, again, taking me back to the timetables that I already spoke about, that on the 9th they had the evidence, on the 10th they had the evidence, they didn't produce it on the 14th, they brought on the 17th at 5. All I'm saying, my lord, is that if that be the case, how persuasive it would have been if he gave us a list of those who had been incarcerated, since he has them now, and claims that they have the affidavits ready now, in order for us to respond.
Would court be wrong to infer or to draw reasonable conclusion or inference that if the petitioner himself could be barricaded, could be imprisoned in his home, then his witnesses who are lesser mortals would even be more vulnerable? Would it be a wrong inference to draw?
My lord, I would not submit on the inference.
No, I mean, just asking.
I think that it is not in and of itself a right inference, okay, because I'm saying on the same basis and on the basis of our immediate past about falsehoods, it could equally be untrue. That's all I'm saying.
Okay.
It is important, my lords, again, just following on that, the last time we were here before you, the same allegations were made.
Counsel.
Yes, my lord.
Attorney General.
Yes, my lord.
Can you address us on this issue of falsehoods? And because there's a court order on record that the applicant was not free to leave his home.
Was?
That the applicant was not free to leave his home for 10 days. Is that a falsehood?
No. Neither did we say so.
So, you represent the third respondent. Were the agents, and your clients the agents who are at the applicant's home?
Yes.
So could you address the court on those issues as well? Thank you.
Well, my lord,
Did you ever give advice? Do we have any evidence on record that you gave advice to your clients that they were breaching the Constitution?
well, my lord, when we were last here, the arguments were that
No, don't talk about the arguments. Answer the questions I've put to you, Land Attorney General.
my arguments, yes,
Thank you.
were that the applicant was being detained because of certain rules that the police were of the opinion he was breaking. What the applicant did through his lawyers was to go to the court, and the court ordered his release, and he was subsequently released. The court also did order that he must follow all the rules. These were both the rules of COVID-19.
I have read the order.
Yes, that's what
You
happened.
should assume that the panel has read the order.
Yes, my lord.
Land Attorney General.
Yes, my lord.
Yeah,
Yes, that's my answer, my lord.
I see.
So, my lords,
I'm giving you 4 more minutes.
thank you, my lord.
Take care of the time we interrupted. Otherwise, your time was up.
Thank you, my
But I'm
lord.
giving you 4 minutes. Yes.
So, my lords, as I was submitting in Raila Odinga, the parties have a basic duty to ensure that they adhere to their respective timelines, and the court must adhere to its own. There must be a level and fair playing field so that no party nor the court loses the time that he or she is entitled to, and no extra burden should be imposed on any party as a result of omissions or inadvertencies which were foreseeable or could have been avoided. That's again in case number 2 in our list of authorities. It is our opinion, therefore, my lords, that the applicant is taking liberties with set constitutional timelines regarding the resolution of a presidential election dispute that was filed on the 1st of February and which must be resolved by the 18th of March of 2021. We submit that it is in fact in the interest of justice, equity, and fairness that to all the parties concerned, that this application is dismissed with costs, and this court proceeds to inquire into the presidential election petition as is envisaged under the law. I beg to submit.
Thank you, Learned Attorney General. That concludes for the respondents.
That's correct.
Can we, Learned Counsel Vega or whoever else is, you have your 10 minutes.
Thank you, my lord.
And you know the rules about
Thank
new
you, my lord.
matter that require rejoinder.
And I will endeavor to keep within them.
Yes.
My lord, to the extent that the 3 respondents have similar answers, I will give one answer, one rejoinder, to the extent that I need it. First, my lord, with respect to counsel for the first respondent, Mr. Chiriowa Chiwanuka, who offered he would have assisted if I had told him of my predicament, and that gives me joy. I can only say yes if he told his client to give the petitioner some space, he would be very fair. My lord, with regard to the 50% time and 10% time allocated in terms of the 15 days, again we submit that our case has been made for special circumstances. While they talk about 50% of the time, counsel for the respondents do not compute the time they deliberately and illegally took away from the petitioner. But it does not stop there, because the case for you now is not the petition. Those predicaments that predated the filing of the petition have continued to punctuate the proceedings that continue today. And that's the reason, among others, why we are here. Where we have been at fault, I have been very quick, my lords, to concede.
Before you go there,
Yes, my lord.
I also think, Council, that if you have 60% or 70% of the time, it is because the burden lies on you to prove your case.
That's correct, my lord.
Yes. So
That's correct, because I have
it
a
would
huge
be
burden.
surprising if you have equal time, then
Actually, my
because
lord,
they could keep quiet.
I would not even be here
Yes.
if we had been allocated at the same time.
Yes.
The difference between a petitioner and a respondent is that the petitioner traverses the entire country to look for witnesses, some of whom are not known, who volunteer. The respondent has a case of responding to only those that I have presented. And therefore, my affidavit points...
No. He or she also has to traverse. Because if you make a serious allegation from Kabong bordering Sudan, they must go to the place to find evidence to controvert.
My lord, that's true. That's
So of course, the strength of your evidence, for them, they need to say, no, it did not happen. But it is you to persuade court. Yours is a higher burden. Sure. But still, for them to respond in terms of geographical crisscrossing, they have to do the same.
That's true, my lord. The difference
Otherwise, they run the risk of this court saying this evidence was not controverted, so the inference is that it is accepted.
My lord, that's
Yes,
true.
yes.
The difference, however, is that for me, I even point out for them who their witnesses would be, because I am accusing a particular person. If I'm talking about the RDC of Amudat, that is the witness. I am looking for people who witnessed the events against that particular person. That is not to say, my lord, that I'm at liberty to play around with the time. I think emphasis has been placed on to the number of affidavits that we're talking about, 200, substantial. Whereas on the one hand, I concede to where we could have been slower than expected. I invite court and counsel for the respondents as well to look at that volume and understand how serious it is for me to come up with that volume. I am fortified this afternoon.
Let me interrupt, just some clarification. What do you mean you have to go and look for someone who witnessed the event happening? If you have to look for someone, how would you have known the event happened? I thought you know that event happened through a witness.
That's not true,
Somebody
my lord.
must have said this happened.
Yes, my lord.
Yeah.
At a particular time, the nature of an election is that I have supervisors or coordinators. One could be coordinating a district. He gives me a story of what happened in a particular sub-county, in a particular parish, in a particular village. So it is a chain from the coordinator. I go deep down. On the contrary, the respondent will receive...
No, before you go, I mean, since you have a supervisor on the ground, district, sub-county, parish, maybe village level, depending on your capacity, isn't it that system? Do you personally have to go there to find, or isn't it that system which identifies that he is the witness, he identified, and then you say, please bring him to Kampala, or we are coming to take the evidence?
Yes, my lord, partly that's
Meaning that you don't go to, I come from Agago district, you don't go crisscrossing Agago to look for evidence. Somebody has already identified for you, you either go and take the evidence and convert it into an affidavit, or you have the capacity, you bring that witness where your chambers are, or wherever you're operating from, because of the other fears you told me.
because of the mobile operations, my lord.
Yes.
Two answers to that, with your permission. First of all, it is true that I would use that system. And that system has also its own ramifications as well. But in the particular circumstances of the case we're talking about, my lord, one is that for the first 10 days, the coordinators cannot even talk to their principal.
How? No, I thought that one was settled. Councillor Bega.
No, it was not settled, my lord.
No, let us not have short memory. In the other application for seeking to amend, we handled this issue of the petitioner was besieged. He was not able to move. Evidence was produced before court that his lawyers and party officials were able to go and visit him. As a matter of fact, his lawyers were able to go to the High Court based on his instructions. You remember we sat in the, not in the tent, in the court hall. I said, if this was the case, why didn't he instruct his lawyers to pursue a petition? You told me he was more concerned with his human rights.
And my lord,
so this thing of, is it 10 days? 10 days he was totally unable to give instructions. I thought you answered it for me.
I did, my lord. Why it continues to run is that the 50% time that is allegedly allocated continues to run through this. But beyond that, my lord, you're going to find that even those meetings you're talking about of the coordinators, I mean, the 10 days was part of the package when he was supposed to meet them and prepare for the case. It did not happen.
No,
so he continues to run
to help your submission, because court is keen to know,
yes, my lord,
the thrust of the submission from the respondents. They are actually not even submitting on the 10 days. They're saying from the day you filed the petition, where you is the petitioner. He was a free man, and in his own affidavit here, and what transpired in court for the other application for, he says, look, I have new evidence. We have crisscrossed, and the word used is we have gone across the country and we have obtained evidence. This is their submission. So by 4th of this month, the evidence was in the possession of the petitioner applicant. This is the argument of the respondents.
And my lord, that
so even when we concede everything that look, which is wrong, and I hope he pursues the Attorney General here for detaining him, besieging him, that is his right. Not in this court, but in the right court for enforcement of rights. You know that. But the argument is that he himself said, I came to court because I had now this new evidence. That's where the argument is. By 4th of February, he had the evidence.
That's not true, my lord.
It is in the evidence. That's what I've been referred to.
Attorney General made reference to paragraph 14 of the affidavit in support, and this is where I want to contextualize. Up to paragraph 14, the applicant was talking about the process he has gone through. Now, paragraph 14 was referring to I paid the prescribed fees for purposes of filing the amended.
Councillor Bega, you're being selective. Let's go to let's begin from 11. He's now talking about the time when he was a free person. And he was left with 5 days only.
Yes, my lord.
In his own affidavit.
Yes, my lord.
He was left with 5 days only. His lawyers started research and gathering of evidence for intended petition. On 1st of February 2021, he filed the instant petition.
Yes, my lord.
And I think I think all the council here said, you file a petition when you have evidence. You don't file a petition then look for evidence. I think this is common sense.
Yes,
yeah. So he says, you did good work. He was able to file on the 1st of February. And by the way, I saw some complaints that I did wrong to give you 3 more days to file the petition. You wanted to file on Saturday, 30th. I said, no, you can file on Monday the 1st. Thereby giving you 3 days. But I saw a complaint that I was unfair.
For the record, my lord, I am not complaining on that.
I saw it somewhere and I didn't understand. But that's beside the point. Then we go to paragraph 12.
And my lord, I speak for this side.
It's okay.
I'm not complaining.
No, that was just a by the way.
Thank you, my lord.
Yeah, not a serious thing. I thought the other person misspoke.
I only say that any statement from the Chief Justice of the land is a serious statement.
Yes.
But I needed to clarify. I'm not complaining.
Then he says, that is after filing. In the meantime, that was after filing the petition. In the meantime, further preparation and analysis of evidence from all corners of the country, I, together with my party structures, obtained, that's what I was referring to when I gave the example of Kabong, obtained more evidence to help in the particularization and support of some of the legal grounds pleaded in the petition. More evidence.
Yes, my lord.
Then 13, you advised him that the newly established information, further particulars, grounds, and prayers were necessary and could only be introduced by way of an amended petition.
True, my lord.
The court declined you to amend the petition.
Yes,
but the court was very clear that whatever you were raising, apart from the other matter which we said was a new matter which you could not introduce after the 15 days. Apart from that, yes, we said all that you needed to do was produce evidence in support because you had pleaded already. This was the ruling of court.
That's true.
When this matter came up.
True, my lord.
And then we proceed to say I paid the fee, and it tells us what we all know.
My lord, yes. Up
Yeah.
to
So by his own evidence, by the time you came to court, he had the evidence. He had crisscrossed the country.
Yes, my lord. Like I did say.
And you were able to tell us that you had 50 affidavits ready, which you could file the same day, and then another 50. You wanted me to give you after 15th. I declined, knowing very well the risk of going that far. You know, that one is on record. So this is the thrust of the submission from the respondents. That from the time the petition was filed, forget the other ones, you actually had evidence in your possession. And it is in the statement of...
May I answer, my lord?
Please.
Yes, it's pretty much for me to answer, but I will make attempts to satisfy you. That's why I'm here, my lord.
Yeah.
With respect to all paragraphs preceding paragraph 17, my lord, the applicant was talking about a process he has gone through. Now, 17, 18 to 23, like I did mention, are the paragraphs in particular demonstrating the inability. Because the inability talked about relates to the filing of the affidavits, thus causing a delay of those few hours, my lord, we're talking about. Now, when my colleagues are talking about dilatory conduct, they're talking about all previous events. No. The dilatory conduct that is referred to as a principle for the grant of the application before your lordships relates to the filing of the application itself, and not any previous. Okay. We agree, we concede, that court orders are court orders. And nobody has a license of disobeying. We did not disobey. We are here because we are demonstrating we failed. We failed for these reasons. We failed by these hours. And we are here to seek your mercy, your prerogative. Because of those few hours, grant us the opportunity to file them. Now, reference has been made, my lords, to a fishing expedition. I hope by fishing they were not referring to fishing literally. That would connote that we are still running up and about. No, we have run up and about, notwithstanding all the curtailing circumstances. The affidavits are here, and I have found fortification in the submissions of counsel for the first and second respondents, when they even made reference to the specific affidavits and the dates, implying that they have actually had an occasion, an opportunity to read the affidavits.
No, you refer, Counsel, please. You refer to them in the application.
Thank you, my lord.
And that has I have not read them, but I have read them in your own application.
Yes, my lord.
Yes.
We have actually...
I've read about them.
Again, a bigger burden, attempt to discharge a bigger burden.
I think there are even annexures of the first page,
yes,
or something like that.
I am corrected, my lord. Yeah. What the annexures actually refer to is an index. They are providing indices.
Something like that, yeah.
Not the dates of the affidavits, etc.
Okay, fine. That one came from court. Now,
I had a duty, my lord,
confine
to
yourself
answer.
to new matters
Now,
that was raised.
Once special circumstances have been placed before court, then the court finds the reason to exercise its jurisdiction. My lord, with respect to prejudice, I agree. There will be some inconvenience to counsel for the first respondent and to the parties across the side. But that's not the prejudice that the law is talking about. Prejudice relates to inability. Now, some extra strain is acceptable. Just like I'm going through some extra strain because of the, I don't want to say the conduct of the Attorney General, but people serving the Attorney General. There is uncontroverted evidence, my lords, before this honorable court. One, that the officers of the Attorney General have misconducted themselves to the extent of disabling this process. I have talked about abductions. Abductions by their own nature are illegal. The Attorney General has not learned from the previous decision of the High Court that his conduct was illegal. And I'm referring to his with immense respect. I'm not referring to the person of Honorable Biaruhanga. His people have disabled. For example, there is evidence on this record that his officers only vacated the petitioner's, the applicant's office on the very last day court had granted for filing evidence, in the evening, when there is no more time. He has not controverted that, but he thinks it's not a disabling factor. In certain circumstances, people would be precluded from raising certain arguments when they themselves are culpable. The evidence I intend to produce before this court is incriminating both the Attorney General and the first respondent. And all I'm asking, allow this evidence to be presented. Then it will assist the Attorney General, even in future. I think he has laboriously been making reference to the amendment of the rules, which we are pleased with, and made reference to the authorities, for example, the authority of Raila Odinga.
You know, the Attorney General and the other learned counsel, I think all of them have said, you talk about abduction, you talk about detention of certain persons. You've not named a single. In other words, court should only believe you if you had said, these were our witnesses, this one was detained in Kawempe police station. What were the ones that had gained notoriety? Nalufenya, we read about Nalufenya, or Masaka, or Ngulu, so that court can believe you. That's really the substance of their submission.
I accept the burden, my lord, being on me.
Yeah.
I do not accept it as professional that the Attorney General who is holding on to these people can still ask me for the names. But in the event that he wants
he
the
can't.
names,
He will not know. Learned Counsel Obebe, the Attorney General does not go supervising police stations. See, you bring the issue to the Attorney General if you're telling me that on this day we wrote to the Attorney General about these persons who are detained without charge in this place, that would be a different matter. Until it is brought to his attention, until a matter is brought to my attention as court, I will not know. So I think for the Attorney General, we should also know.
my lord, yes.
I'm not defending the Attorney General. Yeah.
My lord, that's true,
Yes.
and I receive that guidance with gratitude. But he's not entirely blameless. He has been reading the record.
Well, I didn't say that. I didn't say he's blameless,
Lord.
but with regard to what you're telling
I'm
me.
only asserting my point, my lord.
Okay.
My lord, the last time we're in court, they have been reading the record selectively. They are not making reference to the complaints I raised in court, including the siege over the petitioner's office, which they did not leave until after the time had lapsed. So, my lord, we're talking about the circumstances being different in this case. My lord, can it be a coincidence that they left on the same date after the time had elapsed and they were not hiding anything? The accusations you're going to find in the affidavits I want to place before your lordships. I'd have read paragraph 32 of the petition, the application, in the affidavit in support.
When was the siege at his offices?
Immediately after election, my lord, I did mention that.
Okay.
And until...
Different from his home.
True, my lord, that's different. I don't want to mention to lay the evidence from the bar that we have even gone ahead to file a case in the High Court over the seat.
So what was his office is the same as party offices?
Yes, my lord. That's
So when
the
you say
office I'm
his
talking
offices,
about. It's a
you're
national office.
You're talking of the party offices?
Yes, the party office.
Okay.
So, my lord, yes, I agree these are some of the issues we would have discussed away from the bar. But even when I raised it at the bar, the Attorney General did not help until that time. But I will proceed with the rejoinder very briefly, my lord. I have mentioned, I did explain the circumstances of how we ended up filing on Tuesday and on Wednesday and not before. But let me emphatically say, my lord, the reference that has been placed to the case of Bitaitana Kananura, I think has also not been properly contextualized. That authority is talking about deliberate falsehoods. The case before you is where a lawyer is explaining. And that's why I was very quick to concede and say,
No.
True.
Councillor Bega, you are a much better person just a few hours ago. I think if I were you, I would not go back there. You did very well. This was, and I take great exception because it is my profession. It is something I'm very proud of. And we learned under the tutelage of very senior persons whom we are proud to have belonged to them. And you are now senior, you'll continue to be senior, and many people will learn under your tutelage. A lawyer should never, ever state clear falsehood in the name of helping a client's case.
True, my lord.
Yes.
Let me give assurance.
So for me, I left that, and in another matter, by the way, I can tell you this, in the Court of Appeal, where in an election petition, a lawyer went fishing witnesses of the other side to persuade them to change their mind. I had the matter reported to the Law Council because that was a very serious professional misconduct.
True, my lord.
Yes.
May I give assurance?
So when a lawyer lies and it is plainly, it is clear it is a lie, I would have acted otherwise. I'm not doing that because you conceded and it ended the matter. So don't go back there.
I appreciate, my lord.
Yes.
The point I was demonstrating is that as a professional, I came on record and said, no, I am not contesting the statements in the registrar's affidavit.
I say don't go back there because we concluded it. Just proceed on other things.
I'm obliged, my lord, and
Yes,
I take gratitude in that.
Yes.
My
Don't
lord,
open healing wounds because it's not good.
I hope they have healed, my
They
lord.
have. To me, they have.
My lord, reference has been made to the necessary steps. I think we are in court to seek the discretion of this court because some necessary steps were not taken in a timely manner. And that's why we're here to appeal to the discretion. My lord, it is true, I also mentioned that we would generate skeleton arguments just to facilitate the expeditious conclusion of this. But that did not relate to the time that, yes, we are now ready to do this. No, I said after. I meant after. We have done the scheduling, etc. We would do that, and that was before we received the guidance and direction of court that we would be filing written submissions. I made the statement in anticipation that we needed to expedite, and that's when I said yes. But that can only be done after evidence has been collected. Okay. Reference has been made to bringing this matter before your lordships in bad faith. I took solace, my lord, in your guidance that you're going to deal with the matter before you. I am not the kind of rumor monger that would go around listening to things that people say about justices. The statements by the Honorable Stephen Tashobia would have been much more helpful, especially having said that he watched. One, if he gave us reference to the TV station he watched, the radio station he listened to, the newspapers that he made reference to. We were not provided with that. And that's why preliminarily I made specific undertakings on this subject. I am courteous enough not to make certain statements with reference to a senior friend, my land friend, Stephen Tashobia's affirmance. I was avoiding.
Councillor Begwa, I'm sure you were here when I responded to the concern by the Attorney General on this matter.
True, my lord.
I said whatever has been expressed outside, however unfortunate, does not in any way influence me either positively or negatively.
Thank you, my lord.
Yes. So
the only reason I'm making reference to them is because counsel for the second respondent, who is the author of the affidavit, made submissions on it.
Yes.
And the submissions are on record.
The beauty of being a judge is that you operate from a higher moral ground. I cannot descend into the arena and say, oh, you said this. That takes care of itself.
My lord, that expresses my envy.
For as long as I sit in judgment, it doesn't matter what you think of me. In any case, I do not judge to please any person. I judge in accordance with the law as I understand it. And many times I'm wrong. I mean, that is how it is. But that's the law as I understand it, and I apply it to the evidence. Those other extraneous matters,
I am 45.
Don't lose any sleep about it.
Thank you,
They
my
don't
lord.
influence me one way or the other.
And that answers reference to Article 128, my lord. From our side, no one is coercing or influencing the decision of court in any way. My lord, yes, I think maybe court this time will guide us on what amounts to pleading. Our understanding is that in a matter like this one, where proceeding is by evidence, by way of affidavits, pleadings are not closed until affidavits are on record. But we stand.
So when do you then file evidence? When do you then adduce evidence?
They are used interchangeably in my submission and understanding, my lord.
My understanding, I don't know. I need to look at it again. My understanding was you prepare the petition as the petitioner.
Yes.
You swear an affidavit. The affidavit you swear in support of the petition is part of your pleading. Yes. That is why hearsay information or hearsay evidence is allowed in the affidavit that supports the petition. That comes with the petition because it's looked at like pleading in a plaint.
If
that was my understanding.
If that be the case, my lord, then
no,
I have
I'm not
to
conclusive, but as I said, I'll look at it.
My lord, I have no reason to contradict you, but if that be the case, then I want to contextualize the understanding of the applicant, that his understanding, and that's my understanding, is that these other affidavits which support the affidavit and petition of the petitioner,
which are treated different because if it is hearsay evidence, we can reject.
Yes, my lord.
Yes.
But I am happy to receive your guidance. But that's the context. The context is not to tell a lie that, pleadings are going on.
No. Nobody has said that is a lie. I mean, the worst that I can say is that it is a misunderstanding of the law, but not a lie.
My lord, it has been the submission of the learned Attorney General that the applicant thinks that an inquiry is an inquiry into electoral matters, yet it's an inquiry into the petition. I agree, it's an inquiry into the petition.
The matters are in the petition.
Yes. The matters we are talking about, we are inviting you to inquire into, are matters that relate to the petition. Yep. We are talking about evidence in support of the petition. And when you accept this evidence, you will find that it is spot on in terms of supporting this petition.
Thank you.
My lord, the authorities that have been made reference to...
You have eaten up your time. Can you use 3 minutes and wind up?
My lord, I will actually use 2. Thank you very much.
Oh, wonderful.
1, the authority of Raila Odinga, which has been made reference to in Kenya. First, there was an observation. It was during the hearing. 2, that the Supreme Court Act of Kenya, which exists, did not permit the prayer that was being requested for. Ours is a hybrid of the presidential election petition rules together with the Supreme Court, the Judicature Supreme Court rules, which have room for extending time, and more particularly in a matter like this one, where this court, and I believe rightly, I agree, rightly, guided administratively for proper case management. We are not barred from applying for extension of time. That's why we are seeking leave. And that's one thing I needed to point out. The second principle in the same case...
No, you're leaving out something. The presidential election petition rules are fettered by the
Yeah, hello everyone is watching and listening in. Sorry, I've just lost audio and I'm trying my best to reconnect. Kindly hold on. Sorry, I just lost audio. And I'm trying my best to reconnect. But you can hear from what the judge Owinyi's, the way he responds, the way he interrupts our lawyer, Honorable Medadi Segona. It's like he doesn't even want to hear what Honorable Segona is saying, as in he's acting like a lawyer, defending the Attorney General, defending all the respondents, continues actually to simply just, expose who he is, as in it's really ashaming, because this guy has to be neutral in this. But the way he's defending the Attorney General, the way, fact of the matter, these guys sealed off our NUP office since the last day. The court said it was, the last day to submitting the affidavits. So how would you expect all the 200 affidavits to be filed within one night, or within actually less than a day? Affidavits that have to be, man, these guys, I don't know even which kind of food they eat such that we don't give it to our kids, because we want our children to have a sober mind, man. It's really ashaming. There are certain things that are obvious. Why would a court decline receiving affidavits, evidence that is going to help them make a fair judgment? It's really ashaming. As I try my best to reconnect the audio, just hold on. Just hold on. Let me see how I can restore this audio. Let me see how I can restore it. It just disappeared. It just disappeared. Those watching from Twitter, continue retweeting this, and those watching from YouTube, continue sharing the message, and as well as subscribing to our channel for all instant updates. Just like I told you last time that I'll make it, I'll make sure that I bring this to you live, because we have to get to know about what's going on, and we can easily tell, we can anticipate what is going to happen later on. Come on. Trying my best to get back the audio. Oh my goodness, come on. Okay, let me not bore you. Let me first give you this revolutionary tune as I restore audio. Yeah.
Uganda is bleeding, people are dying, we've heard from above police brutality. We raise our voices to everybody who can hear us, and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us, and call upon every nation, please offer us some help. So much out of our control, whatever's being done around, shooting us without control, but we cannot fight anywhere. We are just unarmed citizens seeking for change in our nation. We only raise our voices high, yearning for change in our country. Our Ugandans got no right to speak of what goes around. No humanity in the government is taking our peace away. Raise our voices to everybody who can hear us, and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us, and call upon every nation, please offer us some help. Mighty God, we ask of you, innocent children the regime has massacred. Uganda's their own country home. Uganda bleeds because of them. It sheds tears because of them. You've tortured us in every way. You've taken a peace away. Voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise a voice to everybody who can hear us and call upon every nation. Please offer us some help. Katonda tukumire President waffe Kyagulanyi byesuubi bye tulina mu Uganda yaffe. Abaana bakaba buli omu asinda tetulina ssuubi lyonna. Kyagulanyi ly'essuubi lyaffe. Mukama tuyambe tuwange. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We are dying.
We are not going to give up. We are not your slaves, and we are not going to be slaves in our own land.
Uganda is bleeding. People are dying. We've heard from above. Police brutality. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. So much out of our control. Whatever's being done around, shooting us without control, but we cannot fight anywhere. We are just unarmed citizens seeking for change in our nation. We only raise our voices high, yearning for change in our country. Our Ugandans got no right to speak of what goes around. No humanity in the government is taking our peace away. Raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. Mighty God, we ask of you, hear our humble cry. It isn't easy for us offer us some help. We raise our voice to everybody who can hear us and call upon every nation. Please offer us some help. We are dying.
We are not going to give up. We are not your slaves, and we are not going to be slaves in our own land.
Uganda is bleeding. People are dying. We've heard from about police brutality. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. So much out of our control. Whatever's being done around, shooting us without control, but we cannot fight anywhere. We are just unarmed citizens seeking for change in the nation. We only raise our voices high, yearning for change in the country. Our Ugandans got no right to speak of what goes around. No humanity in the government is taking our peace away. Away. Raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. Almighty God, we ask of you, hear our humble cry. It isn't easy for us to just dictate away. We are losing our beloved ones, parents and innocent children. The regime has massacred Uganda's their own country home. Uganda bleeds because of them. It sheds tears because of them. You've tortured us in every way. You've taken our peace away. Away. Voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. Katonda tukumire President waffe Kyagulanyi ly'essuubi lye tulina mu Uganda yaffe. Abaana bakaba, oh, buli omu asinda, tetulina ssuubi lyonna. Kyagulanyi ly'essuubi lyaffe, Mukama tuyambe, tuwambe. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. Come and rescue. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We raise our voices to everybody who can hear us and call upon every nation. Please offer us some help. We are dying.
We are not going to give up. We are not your slaves, and we are not going to be slaves in our own land.
Friends, I think I've been unable to reconnect to this audio, but I'm going to be on standby and trying my best to see how I can bring this to you live again. Remember, this has been the second time when I'm trying. Yeah, I'm going to try the third time. Remember, at first it abruptly went off. Even now it has done the same thing. But yes, you know, we have to get to know what's going to, you know, come out of the court. But let me keep trying, only that in order to save your data and not to waste your time, I think I'm going to go off for now. And once fully reconnect, I'll come back live. Yeah, I think that way it will work for much better. Let me see before. Okay. All right. Oh my goodness. No, I'm not singing it. All right. Anyway, Owinyi Doro is acting like a lawyer, is acting like a judge, is acting like how should I describe him? Is acting like someone who is is simply highlighting issues on behalf of the respondents. Is like a lawyer, is not a judge. So, in brief, is not fit to be on the panel. That's the fact. I think this court hearing, the first two sessions, at least they have managed to show you the true definition of the man himself. So to me, he's not fit to be on this panel. But of course, our president came out long ago and highlighted this, and actually he mentioned 3 of them, they should be off the panel because they are not fit to be on the panel. So allow me first stop here for now. But please don't forget to hit that subscribe button, and as well as turn on that notification button if you haven't, such that each time we go live, you get to know, you get the updates in real time. All right, thanks, peace and love.